Good morning. May it please the court, Joshua Watson for the plaintiff and appellant Brian Brown. I'd like to reserve 5 minutes for rebuttal. The parties in this case agree that Brian Brown is a person who has a disability. They agree that he is able to perform the essential job functions either with or without accommodation. They agree that he applied for employment, and they agree that he was not hired. They agree that the rubric that was used by the employer to decide whether or not he would be hired was restricted to a 5-question standardized questionnaire. So all of that is agreed upon by the parties. And then where we diverge is what was said during that interview and what legal significance is there that there are two different stories. So what I would first point out is that if we were to go through, certainly when I go through and I look at the evidence that's been provided in terms of what Mr. Brown says he said and what Cemex says he said, and then what Cemex says the scoring rubric was. If I take what Mr. Brown says he said and I compare it against the rubric, he picks up enough points to end up somewhere in the 16 to 20 score, as opposed to the 9 that he had. So that's why the difference matters. So to give an example, for example, I think that the questions that matter most are questions 2, 4, and 5. And so, for example...
Before you get into that, I just want to ask a sort of foundation question. Is it possible, I understand you don't think that this is this case, but I'm asking just generally, is it possible that there could be a discrepancy in how the rubric was applied, but not have that be evidence of discrimination? I mean, it seems like your case is built on the idea that it doesn't look like they actually followed the process they said they were going to follow, or the criteria they said they were going to employ in figuring out who to hire. And so my client is disabled, and everyone knows that, and so we're going to have that inference that they didn't follow it for him because of his disability. I understand that's your argument. But is it possible that you could just have not following the criteria and not having that be connected to disability? Or is it your position that in a case where you have a person seeking a job who is disabled, then that is the necessary inference?
I understand, Your Honor. Thank you. I believe that is entirely possible, and that it is a question of fact for the jury.
Okay, so in that kind of a scenario, your position is you can just never resolve this at summary judgment. You've got to go to trial and let the jury weigh that. And whether they think that the failure to follow the criteria was connected to disability or some other benign reason.
Well, I think that our case is a little different from that, and so I would hesitate before making that categorical of an assertion myself. I think that this case is different because we have the corollary information about what the plaintiff represents are misrepresentations by company witnesses about what they knew and perceived about Mr. Brown's disabilities. And so that's the line of testimony that talks about the time that Mr. Skulik, the vice president, Mr. Ramirez, an operational supervisor, came down to the Tykert plant that was in Roseville that was being switched over to becoming a Cemex plant. And so there's the testimony there about how Mr. Skulik and Mr. Ramirez both visualized Mr. Brown when Mr. Brown was getting off of work and he had gone through a locker room change. And so he had come out, and instead of wearing his regular work clothes, he was wearing shorts, and his prosthetic was very visible. And when he was in the process of doing that, he had an interaction with Mr. Skulik and a separate interaction with Mr. Ramirez. And that is something that those two gentlemen say did not occur, that the Cemex folks say did not occur. And yet there are the declarations from the other employees. They say, to be clear, they say that they weren't even there for that. And then we look at the employee declarations to say that they were there for that.
But there's no dispute that all sides knew he was wearing a prosthetic device.
The question is to what degree, yes, the question, what there's no dispute about is that Mr. Skulik knew, and that Mr. Skulik had learned through a process where he talked about it with a union rep. But there was a dispute as to whether Mr. Ramirez knew. Mr. Ramirez did not acknowledge that he knew. And both of them, I think it's important in this case because it's going to be viewed in the totality of the circumstances if it goes forward. Why is it that Mr. Skulik is downplaying the degree to which he knew? Why is Mr. Ramirez saying that he never even went to the facility, never even saw the issue with the leg? And so then that adds to the context. So if I wouldn't come to you or any other court and say that because of that testimony simply that we have from Mr. Skulik and Mr. Ramirez that we prove discrimination, but it's the totality of the circumstances. We have the company saying we have a standardized way that we score things. We have their notes about what happened. And we have, very importantly, we're not just saying that they didn't score fairly. We're saying that they didn't apply the facts fairly according to their own notes. We're saying that they misrepresented what the facts were, misrepresented what the words were that were communicated by Mr. Brown. So you have people on the panel who are saying Mr. Brown said A instead of B, and then they score him low. And those same people are saying, oh, no, I didn't even meet the guy and see his leg. With the amputation and the prosthetic. And so the position that I'm advancing is that in that full context, a jury could reasonably say, I don't think that the employer here, or the employer's representatives are being honest. I think that they really did have a discriminatory intent. And, we do have that case authority that talks about the idea of mendacity. And so when we talk about the Reeves and the St. Mary's cases, it is a somewhat a limited space. But if the employer is basically caught in lies, if they are saying, and lies is sort of a red line, but it's an employment case. So, if the employer's representatives are misrepresenting.
What were the lies of the employer's representatives?
So there it is the distinction between what Mr. Brown says he said and what the company representative said he said in the interview. So, for example, those are the ones that I would focus on would be questions 2, 4, and 5 in the record. So, for example, question 4 talks about Mr. Brown being asked, when did you encounter a particular problem with a customer and how did you resolve it? And Mr. Brown says, that he gives this very detailed example. He names a customer, he names what happens, and the account from Cemex, it doesn't have that. And then they score him very, very low. On that one, they gave him a 2 out of 5. Question 5 talks about a time that you had or Mr. Brown had
Okay, so I know you're going to do the totality, but let's focus on just that one for a second, because I'm still sort of wrestling about how I think about this analysis. So, if we take his evidence as true, as we have to at this stage, there's a discrepancy. He gives a lot more detail and flavor to the answer. The legal standard is that we have to have a because of disability inference. We have to connect it to his disability. There's nothing about question 2 that gets at his disability. There's nothing about, as far as I understand, there's nothing about the question or the answer that relates to his disability or his status as an employee or anything that would sort of bring a whiff of that into this. So again, I understand the totality, but if I'm just looking at that, the fact that he's a disabled person and that there was we'll say an error in how they assessed this interview and how it went, that doesn't automatically provide the link. Would you agree with that?
I do agree with that. And I think the question here, and why I think it's a question for a jury, is when we do put it in the totality of the circumstances, how do we interpret the subjective intent of the interviewers when they write the notes the way they do? Because I agree with you. I think I agree with you, that there are circumstances in which a juror might say, a finder of fact might say, people take notes differently. Right? And maybe these notes just aren't good notes, but maybe what really happened here is we're just talking about a different evaluation of an interview. And there's another world in which a finder of fact can look at the same set of information and say, no, like you're omitting key information. What is this business about, not admitting that you know about the leg? Why are you downplaying that? And infer from that mendacity and the context that there's a discriminatory intent. But as in many discrimination cases, and not all, of course, but as in many discrimination cases, the discriminatory intent needs to be inferred in this case. And I would agree that in this case, there is not an email that said we're not going to hire this guy because, he's an amputee. Nobody expressly said that to him. We don't have express jokes about his, a disabled status or anything like that. So it really is a question of whether you can infer from the totality of the circumstances.
So I want to make sure I understand your position on the record. So the legal standard, as I understand it, is at this point, the plaintiff has the obligation to produce some evidence suggesting a discriminatory intent, some evidence. So you would point to there's a discrepancy on how many of the interviewers knew he was disabled because they're denying it or suggesting that they didn't see when there's evidence that they did. You would say that a couple of the answers, unlike the one that we just were talking about, the omission did have something to do with his disability. He says that he referenced his being disabled in an answer, and then their summary of the answer to that question has no inference of disability. So I guess you would point to that, correct?
Yes.
You would point to the fact that he's disabled and he wasn't hired.
Yes.
What am I missing?
There is the notion that in an appropriate business activity, absent some sort of animus, there is no reason for the interviewers to misrepresent what Mr. Brown said in their notes. And the fact that they misrepresented what he said in their notes in order to give him a low score, because if you take their rubric and you take what he said, he gets a much higher score. And so the fact that they misrepresent what he says and then give him a lower score raises the question, why are you doing that?
But why do you draw that inference? That's the thing I'm struggling with. I understand that argument entirely, but there could be all kinds of reasons, as you admitted just a minute ago, there could be all kinds of reasons why the notes are bad. These interviewers are sloppy. Their intent is to just kind of shorthand summary, not detailed recounting of what was there, right? Like there could be all kinds of reasons why there's a mismatch between his memory and their notes that have nothing to do with discrimination. So I'm looking around for what is the thing that tells me that the jury could say the explanation is discriminatory. And what I'm mostly finding is this is a disabled applicant.
A disabled applicant and the employer misrepresented their knowledge of the level of his disability. Well, the level of their knowledge of his disability. Why are they misrepresenting?
What do I do with that fact when it's undisputed that one of the three interviewers in the room did know and wasn't denying the fact that he knew? Couldn't we just assume that everybody in the room knew? At least one of them did.
One of them says that he knew, and the others say that they did not know. Mr. Ramirez says that he did not know. Not say that he does not know when he does know, and he saw it. And then there is this notion of Mr. Skulik testifying that Mr. Ramirez had never visited the plant. So if we take Mr. Ramirez and we acknowledge that he's saying that he didn't know, but Mr. Ramirez, according to the testimony of the plaintiff and those two witnesses, came to the plant in Roseville, observed Mr. Brown with his prosthetic exposed, and so he knew. Why in the world would Mr. Ramirez say that he didn't know? Why would he say he wasn't there? Why would Mr. Skulik say that Mr. Ramirez wasn't there? And in the context of this case, it's sort of strange to think that he wouldn't be there, Mr. Ramirez, because Mr. Ramirez was an important operational manager, and they're buying out this big plant that's, it's a big transaction. Of course, the regional operations person is going to take a look at it. And then the two folks who were the witnesses, the employee witnesses, said that, yeah, he came there, he moved around equipment, he made a bunch of trips. And so it is that appearance of misrepresentation. It's not the appearance, it's an actual misrepresentation that provides a taint that moves into a reasonable question where a reasonable juror could say, I just don't believe him. I think it goes back to this idea of, when you're at trial, if you, and as we instruct jurors, you're at trial, if you don't believe a witness about something, you don't have to believe them about anything. And so there's something odd going on here. There's something odd about the way that they're not fairly documented.
I just want to clarify one point before you sit down, which is that I want to make sure I'm not missing anything here, but the district court said that he failed to meet on his prima facie burden at the third prong, that is the causal connection, the because of, right?
Yes.
And I gather your response to that is that certainly there was enough evidence to get beyond a prima facie case.
That's right, Your Honor. And I realize I've talked all my time. If I can, I guess just close, is that, here there is this, in the factual pattern that we have, there is this sort of factual unity between the prima facie case and then the proposed, alternative business reason for why he wasn't given the job. And it's not as though we have one set of facts that we say, perhaps in an interviewer made a joke about, disability or something, and so we infer animus, and then separately the application process comes back and cures it. It's that those things are factually intertwined. If the interview process is unfair and biased and discriminatory, it cannot be the thing that cures the prima facie case, because it's factually the same thing. It's the same transaction.
All right, we'll give you a little bit of time for rebuttal. Thanks.
Thank you, Your Honors.
May it please the Court, Patrick Burns on behalf of the appellee. Appellant's position in this appeal here today and in his brief all boils down to the main contention that the interview scores were wrong, that they were graded incorrectly, or that somehow there's a disputed fact as to what was said in the interview. But ultimately, the law provides that the wisdom or the correctness of an employer's criteria does not establish an inference of discrimination under the prima facie burden in Step 1 of McDonnell-Douglas. That's especially true where the employer makes the determination in good faith. So the Weil case from California talks about that. This court's decision in Dodson is directly on point.
Well, he's saying that it wasn't in good faith. There's a factual dispute.
Your Honor, he's brought forth no evidence that it was not made in good faith. Every one of the interviewers has testified that they scored them. As already pointed out, one of the interviewers, definitely one and possibly two of the interviewers didn't even know he had a disability, and their scores were similar to the other one. So where's the evidence of this lack of good faith?
He says that they really did know about the two of them. He talks about Ramirez. Is it Ramirez?
Well, Your Honor, the awareness alone is insufficient. I mean, age discriminations, you can tell someone's age, or certain other protected categories, right? You often have an awareness, but many cases, including the Chisholm case that we cited to in our brief, says that an employer's awareness alone doesn't establish discrimination. And Judge Forrest really touched on it in one of the questions, which is it has to be a connection, a bridge, a nexus to discrimination. He has failed to show that. So let
me ask you this. So he says, this is what I really said during the course of the interview in answer to these questions, right? He says one thing.
Right.
Right? And the notes show something else.
He claims that, yes, Your Honor.
Right. I mean, he says that they didn't really record or make note of my answers.
That's irrelevant, Your Honor, because the fact.
Why isn't that a factual dispute?
Well, Your Honor, that factual dispute doesn't matter because the correctness or the wisdom of the internal application has to connect somehow to the discrimination. It can't just be you were wrong, you didn't record what I said properly, I said something different. All of that is insufficient. And Dodson is directly on point. There was an
why don't you just take his argument? His argument is, well, there was other evidence you need to look at in the totality of all the circumstances.
Your Honor, there really wasn't. There was all he's raised is that his interview scores were different, and that's insufficient. Dodson instructs us that, and then this issue of one or two of the interviewers might have had an awareness. Chisholm says that's not sufficient.
But if you put it all together.
But two things that are zero don't add up to anything. I mean, there has to be.
I think his argument on the awareness is that they're lying about their awareness, which is a different thing than just plain awareness. Why are they covering it up, right? That's the fact that he wants to bring out and say that maybe we could draw some sort of inference from that.
That's not true, though, from the record, Your Honor. First, Mr. Skolnick did say he was aware. I mean, he found out about it before the interview. And then as far as Mr. Ramirez, the fact dispute about that, it's not whether he's lying or not. He, I think, said he couldn't remember if he was at the plant that day or he wasn't at the plant that day, and there's a couple of employees that say he might have been at the plant that day. But whether he was there that day or not, it doesn't mean he knew about this disability, that he saw this person, that he interacted with him. There's just no evidence in the record. And actually, if you go back to the briefs, he doesn't cite to these alleged lies. It's not even cited in the brief in the record. He points to those declarations by the employees, but he doesn't even explain what the lie is. And so there really isn't a lie here. And all these disputed, this is really just a plaintiff trying to manufacture an issue of fact to survive summary judgment. I mean, imagine how easy it would be for a plaintiff
Well,
to simply...
our case law is pretty generous in these employment discrimination cases, that at the prima facie, on summary judgment, the plaintiff has to present very little evidence.
Your Honor, that is true, although I would just add there is sufficient case law that even on prima facie, if you don't connect it to discrimination, it fails. I would also say that this court can easily affirm on the alternative ground that he's failed to show pretext under Step 3. So even under Step 1 is where the district court...
The district court didn't go there, though, right?
Correct, but this court can affirm on a different ground, which is the district court held there was no prima facie case made out, and that was the proper decision because there's just no bridge, no nexus at all to discrimination. But even if you said, okay, we're going to sort of infer this based on a few of these...
Was pretext sort of discussed at the district court, and the district court just opted not to reach it because it decided to just do it on prima facie case, or was your motion focused just on the prima facie case?
No, all of this was addressed below. It's just the district court stopped because it didn't have to go further.
Did the plaintiff rely on any additional evidence beyond what we've been discussing today for pretext, beyond what was presented?
No, Your Honor, including in this appeal. We brought up, we ultimately analyzed, our brief analyzes all 3 steps of McDonnell-Douglas, the other 2 in the alternative, and says, we've satisfied Step 2 by coming forward. Even if we get past prima facie on to Step 2, Cemex has satisfied that by showing there was a non-discriminatory reason. It was the low interview scores. Now the burden shifts back to him to show pretext. And under pretext, there's really 2 things. The St. Mary's case talks about this. You have to show the employer's explanation was wrong, and then you have to show that it connects to discrimination. It's that second part especially that he really fails, right? And there's no dispute here that the interview scores were the only thing that was used to have these drivers rehired when the acquisition was happening. So I want to just...
Did he work a full day?
I'm sorry, Your Honor, what was it?
Did he work a full day? Did the plaintiff work a full day?
Work a full day when, Your Honor? I'm not sure.
How many hours a day did the drivers work?
Oh, I'm not sure, and I'm not sure if that's in the record, Your Honor. But the context of this is important, and I do want to point out one thing, which is a lot of this court's case law talks about how the court shouldn't, quote, intrude into the zone of business judgment. This was ultimately a business judgment case because when the acquisition happened, only a certain amount of drivers could be rehired. They only had a need for a certain proportion of them. What Cemex did, they knew the drivers could drive, right, because they worked for Tight Shirt. They were acquiring this company. It was a competitor. They knew they could drive, so it wasn't a skills contest. What they set up with this interview is sort of like an ability to test the soft skills because these drivers, they do more than just deliver concrete to a plant. They have to interact with dispatch. They have to get to the plant and interact with a manager at the plant and talk to a maintenance employee. They have to troubleshoot certain ideas. And so sometimes when there's a subjective interview test and it doesn't really connect to the job at all, then you're getting down the road of inferring discrimination because what does it really have to do with the job performance? Here, this interview was a way to separate these employees by those soft skills. Cemex knew they could all drive. It was just who can deal in customer relations the best, who can answer these questions about safety the best. And there's no dispute here that the interview scores were the sole reason whether somebody got hired or not. Everyone over a 15 out of 25 was hired on to work with Cemex in the acquisition. Anybody that fell below that, like Mr. Brown, who scored a 9, didn't. And that was simply the reason. With all that, when we get to the pretext prong, if we are past the prima facie, which I would not concede, but if we are on pretext, he has to show both that that was wrong, that they didn't use the interview scores as a basis not to hire him, and that it connects to some kind of discriminatory intent. He has no evidence whatsoever of discriminatory intent, and each one of his points is just refuted by either one of this court's cases or a prominent California case. In the Dodson case, there was an interview given to the employee as to whether they would promote her. She scored low on the interview. They didn't. When she brought her claim, it was dismissed on summary judgment and then affirmed by this appeal. I mean, it's on all fours with our case. It's an interview score. The employee was claiming they said different things, that it was wrong. And this court reemphasized, as it has in the past, the incorrect application of an internal process using that kind of criteria to make a hiring or rehiring or promotion decision is insufficient.
So in your view, what do we do with the fact that he says, well, here was my answer. And they just...
It doesn't matter, Your Honor.
Even though his argument is, well, they didn't include it because they wanted they wanted to minimize what they knew about the effects or the consequences of my disability.
That last part of what you said, Your Honor, is what's lacking. There's no evidence that they wanted to minimize it for that reason. You have to have something. And look, there's many ways you can show this, right? It can be direct evidence. You can have testimony from someone, maybe not just these 3 interviewers, but maybe you interview someone else who had a conversation with them. And this is how a lot of these cases.
In several, I think when he went through several different times when he stated he stated what he said, like to the EEOC and then his own notes about what he said. He does make reference, I think, I can't remember in which context. I'd have to look at my notes. But he does make reference to, he said, one of them, he says, my disability, I was aware of my disability and whatnot.
Well, okay, that's a good point, too, that I wanted to raise, Your Honor. His own subjective assessment or his assertion that it was discriminatory is also insufficient. That's from the U.S. Supreme Court, Palmer versus the U.S. He has to come forward with more. If there was, say, testimony from an employee who overheard one of the interviewers say, oh, yeah, we knew about his disability.
Well, that's not what he's saying. He's saying, this is what I said. And he said, I guess it was the one, question number 5. Is that the one about safety? Which is the one about safety?
The first one is about safety. I think 5 is.
Yeah, I guess it was. I think 1 was about safety, and he says, because of my disability, I was very sensitive to safety.
Yeah, again, even if what he
and he's
says,
saying that wasn't recorded down because they wanted to downplay.
But that
they wanted to downplay.
Wanted to downplay part is what's missing here. No direct evidence. By the way, this can also be shown through circumstantial evidence. You're not just limited to finding testimony from the interviewers. You can show different treatment from similarly situated employees or vice versa. Like, there's other ways to show it circumstantially, and he's never shown that. And if this court holds that all an employee has to do is say, I didn't say that, and because I didn't say that, you must have discriminated against me, and there won't ever be a case decided.
He's saying this is what I said.
Correct, Your Honor. But even if what he said...
And we should have gotten, a district court should, essentially this all goes to the fact that the district court ended this case on the prima facie claim, on the prima facie requirement.
I understand, Your Honor, and I get the sense that perhaps on prima facie you're not totally convinced, but when this court gets to pretext, it's very clear there's no discrimination, and that's where you actually have to come forward with evidence of discrimination. Prima facie burden is one thing, but Cemex has established a legitimate non-discriminatory reason for not hiring him. He scored a 9 out of 25, and only employees who scored a 15 out of 25 would advance. The burden is on him to show pretext.
Was question 5 also, he says that he made a reference to his disability, or to his leg?
The questions didn't ask anything about this.
No, I know, but his answer. He said, this is my answer.
I don't believe so, Your Honor. There's nothing, it's undisputed. One of the undisputed facts in the record.
It was the one where they said, had to do with, where he said, what am I thinking?
It's undisputed. This is in the record on page 101, second volume. There's no questions about his disability, and his disability,
No, but he
I believe, did not come up.
His explanation was he was especially conscious of safety considerations because
of
he
his
was
disability.
disabled.
Okay, I understand.
Right?
That alone cannot, simply because the employee raises that in the interview, doesn't lead to any kind of discriminatory intent. The discrimination and the discriminatory
But if that's
intent.
not reported by the executives who are examining him, doesn't that lead to an inference that they were against him because of discrimination?
No, Your Honor, because again...
They don't want to mention discrimination in their answers because they don't want a disabled person on...
That is a extremely tenuous inference, Your Honor, to draw. And it would be one where any employee could survive this standard if the court were to hold that.
On that particular question that we're talking about, I mean, we also have the fact that each question was a maximum score of 5, and they gave him a 4 out of 5 on his answer to that question that we're talking about. So, I mean, also that's a problem in terms of raising an inference, isn't it? I mean, if they were trying to bury his disability and use that as an excuse, why were they giving him a high score on that question?
But, Your Honor, they probably gave him a high score because he answered that one better than the other questions. I mean, if anything, that cuts the other way and says that he scored high on that, so they actually appreciated that question from him in talking about his disability. Again,
I guess the one I was thinking of was five, question 5. Do you have question 5 there? And
Yes.
what he put in his notes.
Yes, but again, Your Honor,
He said, I guess some people get, when he's talking about a co-worker named Dahl. And the plaintiff said, Brown says, Dahl said, I guess some people get special treatment around here. Why couldn't somebody, if they believed that's what he said, why couldn't they reasonably infer?
that was his subjective statement. That's not what he said. He was reporting from somebody else. And a mere assertion of discrimination.
It says that if you were to not rewrite it, but when the pronoun that he's talking about is Dahl there.
But even if all that were true, and that's exactly how the interview took place, there still would not be an inference of discrimination here. I mean, there's nothing. This was a soft skills test. It wasn't testing anything about his physical abilities to drive. In fact, it's uncontested that he doesn't even have a request for an accommodation with this company or with his former company.
The sentence before that says, I mentioned to coworker David Dahl and shared an incident when I called on the radio to request rock, and David made a comment on the radio that bothered me. He said, I guess people get special treatment around here. Now, when he's talking about rock, he's talking about rock that goes into the cement, correct? On the phone, they're talking on the.
I believe, Your Honor, I'd have to look at that particular statement, but even that would not be sufficient to show any kind of discriminatory intent. Again, it's his self-reported assessment of what somebody believed, which under Palmer versus the United States is just simply not enough. There's got to be some kind of circumstantial evidence.
And it's also an inference that he's getting preferential treatment, not discriminatory treatment.
Right. Exactly. If anything, it's different on that basis. And I think the fact that he didn't request an accommodation, not only from Cemex, but from his former employee, really kind of underscores here that there was no basis to discriminate against this person. In fact, Cemex has carried its burden of showing that legitimate non-discriminatory reason, which was his interview scores were low. It's undisputed that this interview was not testing his physical ability or going into his disability in any way. And that's where a lot of these cases go wrong is the interview is either so subjective and vague and loose, like they're asking strange questions that you can kind of infer. We don't have that here. They were testing the customer relation skills, what you knew about safety, all those things, and he scored low, and that was ultimately the reason why he wasn't hired. So whether this case is affirmed either on the prima facie step 1 or under the step 3 pretext, either way, this court should affirm.
Right,
I'm happy to
counsel.
answer any other questions, but I see I'm over time, so thank you.
Counsel. Yeah. We'll put 2 minutes on the clock.
Thank you, Your Honors. I appreciate it. Just a couple of quick factual things. Defendants take the position, Pelley takes the position that all of the scores from the different interviewers were the same. That's not the record here. There was only one unitary score that was arrived at by the panel, so there's no cross-checking there. With respect to the story, the account of Mr. Ramirez and Mr. Skulik coming down to the plant and observing Mr. Brown's leg, that is detailed with citations to the record in page 18 to 19 of the opening brief. Question number 5 is a really good window into what the plaintiff's case is. In question number 5, the plaintiff is asked about problems with coworkers. He talks about an experience in which a specific coworker talked about him getting preferential treatment. He talks about how he resolved it. He talks about how he thinks it's important in his term to resolve the issue man-to-man, one-to-one. How he's not creating a ruckus. He's going to go and talk with this other employee about the conflict that they had. He's talking about preferential treatment. Some people get it easier than others. As a person who's an amputee, he's talking to a room of people, 2 of which have seen him with his amputated leg and don't want to talk about the fact that they've seen him in deposition, won't talk about the fact, won't admit that they saw him with his amputated leg. There's a nexus there. In the circumstances as they actually occurred, Mr. Skulik and Mr. Ramirez, they misrepresented the degree to which they knew about it and observed.
So your argument is because he mentioned that he was getting preferential treatment company individuals who want to eliminate preferential treatment are discriminating against him because of his disability by not giving him preferential treatment?
No. What I am saying is that there is an indication in the interview that the topic of disability is known. Topic of disability as related to this particular employee, Mr. Brown. We know that from the deposition testimony when I deposed Mr. Skulik and Mr. Ramirez, we know that they took quite extraordinary steps to try to deny the degree to which they knew at the moment that they were in that interview that Mr. Brown was an amputee who used a prosthetic. So we go back to the idea that an inconsistent story that simply does not make sense, plus some indication of protected class and mendacity by the employer, can raise an inference of an animus.
I think we understand the argument, unless
Yes.
there are further questions.
All right, submit. Thank you, Your
Counsel.
Honors. Thank you, Counsel.
All right, the case of Brown versus Cemex Construction Materials is submitted. And that completes our argument calendar for the morning. We're in recess.